Howard Nations from Houston is just a legend in AAJ and among trial lawyers nationally. But one thing you may not know about him was that before he became a trial lawyer, and before he became known and loved by all of us, he was a Russian linguist in the Army during the Cold War. And I'm not sure where that carries through to the development of the skills that he has developed in such legendary degree. In his 50-year career, Howard Nations has been a pioneer in courtroom technology, a pioneer in forensic psychology in the courtroom, a forensic in the neuro-linguistic principles in the courtroom. He has been president of darn near every organization he has been a member of, including the Texas Bar and the Texas Trial Lawyers and numerous other organizations. 2 years ago, he was awarded the AAJ Lifetime Achievement Award, which kind of sums it all up. I'm going to get out of the way and let Howard talk on Know Your Audience, presenting damages to the millennial demographic.
Good morning.
Good morning.
Good morning. I'm going to talk about a wonderful group called the Millennials. And the Millennials are a very, very unique group politically. They're a unique group every way you can imagine, and they are very definitely different as jurors. They approach things as jurors very, very differently from their predecessors, their older siblings, which is Generation X. And so I started studying the Millennials when they got old enough to be jurors. And I've been studying them pretty closely ever since. And you can see, I got a call from the Clinton campaign because I've been speaking on this subject for about 15 years now. And I got a call from the Clinton campaign, and they were asking if I could give them some advice on how Hillary could reach the millennials, because you may have seen the stats that with the millennials, Hillary is down on the downside of an 85-15 split. Bernie's got 85% of the millennials. And so I said, well, you don't need me, just watch Bernie, because he's doing it right, and he is. He's doing it on every level absolutely right, and he's connecting with the millennials. 85%, that's an incredible figure for any demographic. So they are different, and I'm going to talk to you very quickly today about the topic of how we approach them on the subject of damages. So let's talk about them generally first. How do we get millennials to focus on anything, but especially on our evidence? You have to understand their motivations, and it's showing. You have to use show and tell more than any demographic group we've ever seen. The millennials are more about the show part of show and tell because they are extremely visual. So we have to use standard focus techniques in order to do that. We talk about theming. So we have to have a visual theme that is best supported by an actual graphic, something they can take into the jury room and look at, something that you can tie into your closing argument when you make an argument to them. So we're not just to have a theme like profit over safety, the standard themes that we've had for years. Just a word theme doesn't resonate nearly as well with the millennials as a theme that you can tie into a picture. If your theme, one of my themes in damages is that the plaintiff is doing the best they can with what they have left. And we never, ever stress sympathy. We never go for sympathy in trying to prove damages, because that just plays right into the model, the bad model, the tort reform model of trial lawyers. Instead of pleading for sympathy, what we always go for is courage. Courage, the very best, doing the best they can with what they have left. And this is a visual frame for courage. Here's a young man who's a paraplegic. It was a forklift rollover. He's 18 years old, working a job between high school and starting college in the fall, and he gets in a forklift rollover accident, ends up paraplegic. Well, he didn't sit around and cry about it. He's doing the best he can. I didn't pose this picture. I went over and spent a day with this young guy, terrific kid. I went over and spent a day with him. I said, you go through your regular routine and let me figure out what to do. And when I saw him doing this, I saw him working out, I thought, boy, that's the picture of doing the best you can with what you have left. I also have some video of him popping wheelies in his wheelchair, but I left that part out. But so let's talk about who are the millennials. They are so distinct that they refuse to be called Generation Y. They started out being Generation Y, but they are the group that graduated high school in the year 2000. So they said, we're launching into a whole new millennium in our careers, so we want to be known as the millennials. So they wouldn't respond to Generation Y. So they were born from 82 to 02, and they are the children of the boomers, and they're the younger siblings of Generation X. So here's the classic stereotype of them, and it's not just a stereotype, it's actually true. 94% of them have cell phones, 76% communicate. Their preferred method of communication is by instant messaging. 92% multitask and messaging. And they regard themselves as being, as living by the iPhone, which they do. I mean, you'll see them sitting across the room from each other, communicating. I was with a group of lawyers. Mass Torts Made Perfect. And I was with, we had one of the cabanas by the pool, and there were a bunch of lawyers out there. And there were a group of about 6 lawyers that were millennials, young millennial lawyers. And so we're sitting out there, and one group over here, guy over here is sitting there, and he starts laughing. And then a second later, a guy over here starts laughing, and then they all start laughing. I realized that they're texting each other, and they're all laughing at their text. But I said, you guys realize you can hear each other, right? But they don't want to. They prefer the texting. They're the second largest population now. There's 75 million of them, and think about that. They are now very, very actively, they're becoming a larger and larger percentage of our juries now. So we really need to talk about how to communicate with them. So an interesting aspect of how to communicate with them is, how do they self-identify? What do they regard themselves? This is interesting. This bodes well for the Democratic Party in the future. They self-identify in testing as more liberal and Democrat, which you're seeing reflected in Bernie's campaign, the more liberal part. But they're more liberal, more Democrat than ever. 50% of them are entering college, which is the largest percentage that we've had in any generation. Now, their unemployment rate. So you're going to talk about how to communicate with them, and you've got a client who was injured, lost their job, and now you're complaining about they can't find a job. Well, you know, it's welcome to my world. They have a 20% unemployment rate, and they're mad about a lot of things, and they're justifiably mad about a lot of things, and we need to understand what those things are and why. So the unemployment rate starts at, they have less health insurance than any other generation. They have the highest rate of obesity. All those school lunches of hot dogs and pizza that we've fed them in our public school system is showing up now. They have the highest rate of obesity, and it's a matter about which their health is a matter about which they're very concerned. They're concerned about their declining health. They're not as healthy as their older siblings. And they are, at this age, at the age where they are now, they are our least healthy generation. One of the reasons, of course, is that they're not out running and playing and as kids and doing all the things that we did, and all the activities that we did. You know, schools, a lot of schools have even done away with phys ed class. They don't even have an hour a day of physical education. They're spending their time sitting at computers. All their time is at computers and on iPhones, very little health activity, and then they have this terrible, this brilliant idea of let's feed them hot dogs and pizza at lunch at school every day and get them started off on a fast food diet. And the result of it, declining health and obesity. And to some extent, they're starting to figure out they didn't do this to themselves. This was done to them by who? By the school system, by the government system. So here's something that's very different about them, and this is what Bernie is tapping into. They feel that the federal government should do more. Every government should do more for them. They have an adverse view of business for a very good reason. That reason is what? Student loans. They want to have a job with self-esteem. They're not interested in flipping burgers. They want a job with self-esteem. And they're heavily burdened with school debt. So again, when you start talking, when you have a client who has a lot of debt, maybe from lost time from work as a result of a tragic injury, or they have medical bills, they have wage loss, things of that nature. These people identify, but again, it's welcome to my world. I graduated from college, I can't find a job. This is a standard story. I graduated from college, I can't find a job, and I am now heavily burdened with school debt. I have a school debt from college that is greater than a mortgage on a house I could buy if I could buy a house. And so, and after all that school debt, they can't find a job. So they're understandably upset with the system. They're understandably upset with the government, and that's why they think government should be doing more for them. They're understandably, and this is a very important aspect of the millennials, they're understandably very upset with big business. They're very upset with corporate America. They're upset with Wall Street. They're upset with banks, because the banks are the ones that they owe this student debt to. And they felt like they've really been trapped in this student debt routine, and actually they have. So this again, think about it. Why is Bernie, what is Bernie's message? Anti-Wall Street, a rigged economic system. It all plays directly into not only their beliefs, but their experience, which of course is what forms their beliefs. So the result is, and this becomes important in damages, is that they don't rebel against their parents. They're living with their parents longer. They have a closer relationship with their parents. The average now for millennials leaving home, they're staying at home with their parents until age 28. So they have a closer relationship with their parents because they're in the next bedroom. They're still right there. This is not the parents' choice, incidentally, but they talk an average of 1.5 times per day on a wide variety of topics with their parents. So if you've got a case involving loss of a parent, loss of a mother, loss of a father, or loss of a family member of any type, you've got a good prospect with your millennial jurors, because they have a very tight relationship with their parents. The Generation X was largely the same, except the Generation Y, the millennials, are even more so. So they are, now here's where you get, this is more of a liability issue than a damages issue. They're accepting of authority. They are rules followers. When you think about it, they are the most rigidly rule-following generation ever. You know, when I was a kid, if we wanted to play football, we'd go out in the field and start tossing the ball around, and other kids would see us, and then they'd come over. Next thing you know, we'd have enough people for a game, so we'd form up our own game. We'd pick sides, and we'd play football. We'd play baseball. We'd play whatever on our own. Now, everything with these kids, I think they organize them in the hospital, in the delivery ward. Everything they do in teams. Everything they do with rules. They are taught rules in everything. And everything they do the whole idea is we're all one. We're all, you don't want to stand out. One of the things about millennials is they have the book called Everyone Gets a Trophy. So you're not supposed to stand out and be a lot better than everybody else. They don't have the competitive spirit of the boomers. The boomers had a huge competitive spirit, who are the parents of the millennials, have a huge competitive spirit between each other. But these folks are together, they're rules followers, they're the most supervised in history, and they are, as a result of that, you really preach rules to these people. When you're talking about liability, you talk about the violation of a rule, but you don't just talk about it. You show them a rule. You show them the rule, you explain to them the reason for the rule, you explain why the defendant violated the rule, how the defendant violated the rule, and why the rule is important, and that the rule was made to prevent exactly what happened to this plaintiff. You go into details about rules. And if you have a medical protocol, you show that medical protocol in writing. You don't just talk about the medical protocol. You want to show them, you want to stress rules. And you don't want to talk about a medical protocol. You want to talk about this is a rule that doctors follow. This is a rule that doctors are expected to follow, a rule made by the profession, a rule made among the doctors themselves. And so you want to talk heavily about violation of rules, because if you get enough violation of rules, then you get to the point where your liability can drive your damages. Your liability can certainly increase your damages. So the whole issue of rules and there being very strong rules followers is very important, and it plays heavily on both liability and damages. Now, there are more rule followers than any other generation. So if you've got a case where the rules, following the rules is very important, that's going to be maybe outcome determinative in your case, and you're choosing between the boomers and the millennials, the boomers were, this is a generation from the 60s. These are the guys that went out and protested in the streets. They protested civil rights. They protested the Vietnam War. When they were not stoned, they were consciously protesting. When they were stoned, they were unconsciously protesting. So your boomers are a very, very, very different generation than your millennials. And so the attitude about rules is very different among millennials and their parents, the boomers. The Generation X, which fits in the middle there, they're also rules followers, but not nearly as strongly. This generation of millennials, they were born and raised with rules, and so you can't stress rules enough. Now, here's how they self-identify. This is a big, huge survey that they filled out themselves. They self-identify. So this gives a little insight to them. They have a positive attitude, which is true. They are cooperative team players. Goes right back to everything being done in teams. No individuality. They're accepting of authority. Again, rules. And that accepting of authority depends upon the type of case you have. There are cases where someone who didn't follow the rules or didn't follow the authority of a supervisor, these people become they identify themselves as rules followers. They are the most supervised. They regard themselves as the most supervised generation ever, and they are. They're right about that. Next is they regard themselves, as every generation in history, as smarter than their parents. And they're smarter than everybody. And of course, this comes from the fact of having to show their grandmother, their parents, and their older siblings how to use a computer. So they're progressive. Again, this bodes well for the Democratic Party of the future, because this is self-identification now. So they self-identify as progressive. Why? Because they've been raised in a world now, most of them have been raised in a world where the progressive issues, the issues of race, the issues of homosexuality, gay marriage, those sorts of things, these are very normal things for them. And they were raised with it being normal. And so they're very accepting. So they regard themselves as being on the cutting edge of everything. We are, and they are, because they're the first ones to know how to use the new technology, and then they teach it to us. They regard themselves as better educated, and I'm not sure this is true, because their education has become so packaged. I'm not sure they're as well educated as previous generations, but this is how they regard themselves. They think they're smarter, cutting edge, and better educated. And they regard themselves as global, which they certainly are because of the World Wide Web, obviously. So they interact with people around the world on the internet. So now, their near polar opposites are the boomers, who are their parents, and their older siblings. Now, here's something that's important for us. The Generation X was the consummate tort reform generation. And keep this in mind when you're looking at a jury panel. Generation X was raised with the idea that they think greedy trial lawyer is one word. And they were the ones that were there when all the TV ads were being run against us. And so they heard it every day. The millennials, first of all, many of their own members of their cohorts want a law degree, or they have a law degree. And they don't regard, since they are more progressive, and we, for the most part, are more progressive, they identify more with the trial lawyers, and they identify more with the good work that trial lawyers do because they are progressive. So as between the millennials and the Generation X, if you're worried about tort reform issues, be very cautious about Generation X, and you can be a little more forgiving of the millennials because they're more trustworthy from our viewpoint. Now, here are the 12 negative factors, events. You know, cohorts come from from common things that happen to a generation. And these are the negative events this is what formed their attitude about the world. And their attitudes about the world help form their beliefs, and their beliefs help form their opinions on how to decide lawsuits. So obviously 911, the .com failures, corporate corruption, and this is you see something here shaping up. You got a case against a corporation, you got a product liability case, you got a case against a big hospital, the whole big business institution. They see corporate corruption, a divided country, the untrustworthy politicians, the Iraq and Afghan wars, the lack of security, their shrinking salaries, which is another thing. This generation is right now destined to be the first generation where their salaries are actually less than their preceding generation. Their average salary is going to be less than the Gen X folks. And they're shrinking opportunities. So again, when you're trying a case involving your individual plaintiff who now has been injured and he has less money to live on, he or she have shrinking opportunities for finding new employment, that sort of thing. These folks are saying, welcome to our world. Now you know what it's like to be a millennial. The outsourcing of jobs is a big event that took away their job. The insourcing of foreign workers has impacted them, and the downsizing. All these things have to do with their ability to find and keep a good job. And so again, your employee who's lost their job and is now, if you represent a person who's now 55 or 60 years old and they lost their job and now they're out there competing in this world, trying to find a job at the age of 50 or 55 or 60, then these folks can resonate to that because they're fresh out of college with a heavy debt and they can't find a job. And here's the reasons they can't find a job. Now, if you look at that list, the outsourcing of jobs, the shrinking opportunities, the insourcing of foreign workers, and downsizing, that's all, those are actions by whom? That's all corporate actions. So again, you have a whole body of jurors here who are anti-corporate by their very nature. They're anti-bank. They feel that they are personally being screwed by the banks because of the whole deal that was made about the government initially providing funding for education and all kind of government loans, and then they corporatize that and turn it over to the banks, and the banks are the ones that are still now bugging them about collecting on their student loans. So how do we communicate with them? Generically, you prime your information as in a news story. It's the who, what, when, where, and why, and then explain how. Who, what, when, where, why, and how. You sequence your story to show that you have proof to back up your allegations. They do not respond well to hyperbole, which is why I'm thinking about retiring. So what when I talk about sequencing your story, you don't come in and start talking about your damages right off the bat. You don't come in and give a big spiel about damages on voir dire. You qualify them on damages on voir dire, and you set them up to explain what the damages are going to be that you're going to be talking about on opening statement. But you don't come in and prove up all your damages right off the bat, because these folks need to see that you can back up your allegations. So I think the way you sequence is you come in and you prove up your liability, but the allegations that you make on liability, the first things you do, in sequencing your evidence, you come in with hard evidence first, so that you're not just talking. It's not just you saying things. This is what happened. This is how it's going to be. These are the problems. You don't just start out talking about that. You come in with hard evidence first. Hard evidence is photographs, actual numbers, actual figures, things of that nature that are expert testimony that can provide hard evidence. You give them hard evidence as opposed to just your verbiage. And then after you prove this up for a while, prove up your damages, then and you prime your hard evidence of liability, then you can start talking about damages. Keep emotional appeals in their proper place and perspective, and sequencing damaging proof. Your damage proof wants to come. You want to come with what I call the Zeigarnik. Well, I don't call it, but it's a psychological principle, which is the Zeigarnik effect. And the Zeigarnik effect is to the effect that jurors, everyone, will cling most tenaciously to that which they discover on their own, as opposed to that which they are spoon-fed. So you want to sequence your damage proof in such a way that you start out, for example, in a brain injury case, you don't stand up on voir dire unless it's just really obvious to everyone. You don't stand up on voir dire examination and talk about this is irreversible, permanent irreversible brain damage. You start out talking about this is a head injury. It's a head injury case. And then you get into, later you get into injury to the brain. And then it's only after, as you put on more and more evidence, you want them to think, okay, it's a head injury case. Okay, it's a serious head injury case. Okay, wow, this is really serious. And then only after your doctor describes it as irreversible brain damage, then you talk about it in terms of irreversible. You want them to discover it's a head injury. This involves the brain. Oh, this seriously involves the brain. Wow, this is a serious irreversible brain damage. And you want you want them to discover that slowly and on their own, because then it becomes their discovery, not your spoon feeding. The next thing, Plaintiffs should have a definite plan for rehabilitation, because they expect, if you're going to ask them to do something for you, and they've been trained to do this, if you want them to do something for you, the first question they ask is, really, what are you doing for yourself? So you show two things. You show what you are doing for yourself as a plaintiff, and then you show what you will do for yourself as a plaintiff if you have the money to afford it. You have a rehabilitation plan in place, but you need the financing for it. So you show a good use for the award. But, and before you get to the courthouse, you need to think about these things. This is not something you think about the night before when you're trying to think, okay, what am I going to put in my closing argument? What good purpose will be served by an award of damages? Because we hear this all the time in focus groups. So, okay, so you've got a, yeah, it's a tragedy, you've got a dead child, but money's not going to bring the child back. So we hear that all the time. So you have to have an answer to what good purpose, and you make it part of your evidence as to what good purpose would be served by an award of damages. You explain how the money will improve the life of the plaintiff, actually improve it. Or the family, and if you have a breadwinner that's injured, the plaintiff and the plaintiff's family. Avoid a sense of entitlement. They resent entitlement because they work as a team. They don't think that one's more entitled than the other. So you don't ever discuss your client's damages in terms of entitlement. An award of damages in this case will help me to help myself to improve in the future. You're proving up three different scenarios. Number one is the life that the plaintiff was leading before the injury. So there's a test. Compared to what? Your condition today is this, but compared to what? It's so much better if you compare it to something. To come in and say, I'm hurting today, yeah, but how were you, compared to what? So you prove up what the plaintiff was doing, what the plaintiff's plans were, how they were physically, all the good things about the plaintiff's life before the tragedy. Then you prove their present circumstance. What is their condition today? And then the third thing you prove is what is their condition going to be in the future, and what's their life going to be like in the future as a result of the impact of this tragedy on them. Show that the plaintiff is self-motivated. The plaintiff has to have a plan and exhibit the plan of their self-motivation to improve. You're not just throwing yourself on the mercy of the millennials. You're seeking assistance, not a handout. Here's what I'm going to do for myself. I need help from you to do it. Avoid compensating the victim. We just avoid the use of the word victim because this is across the board with everybody. The whole victimization issue goes against us. So we don't talk about the victim. We don't use the word victim, I'm sorry. Prove that the plaintiff is both two things, in need and worthy of their help. So we can always prove with the damages, we can always prove that our client is in need because they've been injured. But you have to prove they're worthy of their help. How do you prove they're worthy of help? You prove they're worthy of the help by talking in terms of how they have their own plan to do the best they can with what they have left, and what that plan is and how they're implementing that plan. It's worthy of their assistance, the assistance of the jury. It's not, here, I'm hurt, tell me, I want you to do everything for me. It's the operative word there is help. The next is personal responsibility is still the generic theme. It's the universal theme. It resonates across the board with every generation. I think it is the universal theme at the courthouse today. And you want to make, with whatever group you're dealing with, you want to make personal responsibility your issue. And you do that on voir dire examination before the defense has a chance to start ranting and raving about this as about personal responsibility. You can tell the jury that we invite you. We're going to invite you in this case to closely examine the conduct of the injured party. And the injured party, Ms. Jones, is fully accepting of any responsibility, her responsibility. As you see in this case, she has no responsibility because she did what you're supposed to do in her position. But if there is responsibility, she accepts it. The reason we're here today is because this defendant refuses to accept their responsibility for what they've caused by their negligent conduct. So make this your theme right off the bat. Now, damages. One of the things we do, and I blame this on the law schools because the law schools don't really teach us about damages. I taught damages in law school for 25 years, and they really don't teach us about how to prove damages, about how to examine every element of damage. So what you want to do is create a body of evidence with respect to each element of damage separately. And I've been doing this. I worked this out over 25 years of teaching it, and now 50 years of actually doing it. So when I talk about this, we want to look at every element of damage there is. But the first thing you do is we have a checklist where we check off every element of damage. We have a checklist for personal injury litigation. And so if it's a personal injury case, we go down and check it and make sure we've pled every possible element. But this whole thing about creating a body of proof, physical pain and suffering is one element of damage. Mental anguish is a different element of damage. You need to think in terms of creating a full body of proof just for physical pain and suffering. And by a full body of proof, you look at we'll get in our war room and put physical pain and suffering on the blackboard. And then we'll look at the witnesses. What is the expert testimony we have on this? What is the lay testimony we have on this? What is the documentary evidence? What is the demonstrative evidence? And what do we have from pretrial discovery that will help us to prove the elements of physical pain and suffering? And when you list all the witnesses who can prove physical pain and suffering for you, then you match them up and you sequence them and you find the documents that will support each one of those people in proving physical pain and suffering. When you get all your physical pain proof together, that's one body of proof. Now you move on to your next element of proof, which is mental anguish. Mental anguish is not the same thing as physical pain. There's so many different variations of what constitutes mental anguish. For me, watching the Republican debate is mental anguish. I mean, that's, as an American, as a Democrat, it's hilarious. It's the best show on TV. But mental anguish has so many different aspects. So you look at every possible aspect of mental anguish at every stage. And I have a paper on that about the sequential approach to it, looking at it at every phase. But you build a complete body of proof on mental anguish. Then you look at physical disfigurement, if it applies, physical impairment, which is also physical disability. You look at bystander mental anguish. You look at loss of society and companionship, loss of consortium, loss of household services, the value of nursing services. You look at every case. Does this element of damage apply to this case in any way? You look at loss of earning capacity, and then the difference between wage loss and wage earning capacity. And the fact that, what do you do about the fact that your client is now back at work making more money than they were making before? They're on a different job, but they're making more money than they're making before. That doesn't preclude you recovering for a loss of earning capacity, because if they can no longer do the job they could do before, they've lost their capacity to earn money in that line of work, and so you have damage to wage earning capacity. Then you look at medical expenses. One of the things you look at, pharmaceuticals, lifetime pharmaceuticals. You take you take one drug, you take 3 or 4 different pills that people are having to take now for their pain, for their muscle relaxers, whatever, and whatever they're taking as a result of this. It doesn't sound like very much in terms of damages, but if you have a permanent injury, you take that and you give it to your life care planner, and you spread that out over a lifetime, over the life expectancy of your plaintiff. You'd be astonished. And at the normal increases in, they calculate the normal increases in cost. They calculate one little thing like pills, and it becomes thousands and thousands of dollars. But not only does it become thousands and thousands of dollars, it raises the point that this plaintiff is going to have to be taking these pain relievers or muscle relaxers or whatever for the rest of their life as a result of this, as a result of the actions of this defendant. So it just stresses the permanent nature of the injury. Funeral expenses. I have I had a young lawyer that was working for me, brand new, just hired him out of law school, and I taught him in law school. And I always taught them, go ahead and plead your damages. Be sure and plead all your damages, because if you plead them and you can't prove them, no harm, no foul if they're in your pleading. But if you try to prove them and you didn't include them in your pleading, then you can be, you may have to try to get a trial amendment or whatever. So he came in, one of my associates came in, and he said, you know, he really took you at heart about this. He said, you need to read this part on funeral expenses. And he had pled, the decedent has experienced funeral expenses in the past, and in all reasonable probability will experience funeral expenses for an indefinite period of time in the future. And so I called him in. I said, what are we dealing with here, the eternal flame? And he said, no, the suit was rented. So, but what the hell, take a shot. Then you want to get into personal property damage, cost of vehicle repair, whatever. Recoverable elements, pre-impact terror. You have to think about that. The people who are looking, I had a case in which this couple is sitting there, and there's a 18-wheeler bearing down on them, and there's absolutely, he sees it in the rearview mirror, and he screams out, and his wife turns around and looks, and they see an 18-wheeler bearing down on them. They're on a bridge, they can't go this way. Solid traffic stopped. All traffic is stopped. They can't go forward, they can't go this way, they can't go this way, and here's an 18-wheeler bearing down on them. Okay, it's a few seconds, but it's pre-impact terror. But that's a classic example. That's of the mental anguish in pre-impact terror. The jury awarded $5 million in the pre-impact terror for the 7 minutes between the problem with the airplane and the fact that it took them 7 minutes to glide down to a crash, and they award $5 million for pre-impact terror for living through that 5 minutes of knowing you're going to die. So you have to think about things like loss of chance of survival. So some states have that, others don't. Attorney's fees, there's so many places where there are provisions for attorney's fees and statutes that lawyers never think about applying for. It's just amazing. Statutory penalties, statutory damages, DTPA, treble damages for consumer protection, contractual damages, bad faith damages, pre- and post-judgment interest, and punitive damages. Now, in the last few minutes, I'll tell you about how do you handle how do you determine how your millennials think differently than your other boomers and your Gen X. And here's how you find out. It's through focus groups. You want to think about how they think about your specific case. So we go into demographics. You do focus groups within cohorts. And a cohort means Generation X, the millennials, their generational cohort. So if you want to think about it, there are a couple of ways to do it. One is you bring in just a group of millennials. We do this all the time. You bring in a focus group of nothing but millennials. So you bring in 12 or 18, whatever you're working with, and then you give them the facts of your case, and then you listen to how they talk about it. You listen to the metaphors they use, the analogies they use, the language. How do they describe the things in your case, and what is their language of the case? And you'll find that a lot of times how they describe the case, their language of the case is going to be different from how the boomers. Then you do a focus group with nothing but boomers. You do a focus group with nothing but Generation X. And then compare, and you obviously video these, and then compare these. And listen to the rhetorical devices, the metaphors, the analogies. You have different metaphors will resonate with the boomers than will resonate with the millennials. So you test those, and you actually you can test your metaphors, which are powerful persuasion tools, and you give them a situation and say, okay, I want you to write the rest of the sentence, and you give them a situation and say, this situation is just like what, and let them fill it out. Whatever they put in there is a metaphor, and you'll find that they have different metaphors than the other generations. You want to do show and tell. You want to test your demonstratives so that you can learn. The idea is to learn to tell your story across demographic lines. You're trying to develop a story that will resonate with all your generations. So you make a simple, non-persuasive, vanilla presentation. And then there's another way to do it, which is you can take 18 panel jury or 21 panel jury, and you make the same vanilla presentation to all of them, no difference. And then you divide them up. You've got 7 millennials, you got 7 Gen Xers, and you got 7 boomers. Now you divide them up into 3 different groups and give them the same questions or the same basis for discussion, and then you listen to how they discuss, having heard exactly the same data, how did the 3 different groups discuss this differently, and then how do they discuss it the same? Because when you hit those points about how they discuss it the same metaphor that resonates with all 3 groups, the same demonstrative resonates with all 3 groups. Now you're talking about something you're using in your trial that resonates with everybody. So you videotape them, and then you let them deliberate on their own. You give them written questionnaires. You video all proceedings. Your large group. That's what I was just describing. You're looking for language of the case, metaphors, and a rule of 3 quiz. At the end of it, I'll say, okay, write down the 3 things, the 3 pieces of evidence that were most important to you. This is after they deliberate and arrive at a decision. Then you write down the 3 pieces of evidence that you thought were most important in the case. Do that with all 3 generations and see what differences you get. What were the 3 most important elements of damage that you heard? What were the 3 things that caused you to, what were the 3 most important things you heard on liability? And then you ask them about you test your metaphors on them. You test your graphics, you put your demonstrative. I never ever showed a demonstrative to a jury without having tested it with focus groups. You test your graphics, you test your timelines, you test your rules, see who resonates to the rules. And then you test your medical protocols, and then you put it all together, come back with different focus group, and test your cross-generational storytelling, test your case-specific facts, and test responsive to each elements of damage and how they responded to by each different group. That's absolutely everything I know about generation X, Y, and damages. I hope I've said something that will help you, help your clients. Thank you very much.